Welcome, everybody. This will be an impulse talk about the law of democracy and racial equity by Professor Joshua Salas. I'm really happy to welcome here tonight, this afternoon. It's just getting a little dark. We've talked about ideas and ideals, about literature and philosophy. I've talked about how actual politics are working and policy making works. And Joshua Yaffa just talked about an actual battlefield as well. And what we haven't talked about yet, and which is also a very vital part of democracy, is the law. And Joshua Salas will do that. He's an associate professor of law at Arizona State University, and he's also a Mercedes-Benz fellow at the American Academy, and that's why we're lucky to get him down here from Berlin. He focuses on election law, legislation and regulation, constitutional law, and civil procedure. Joshua Salas received his bachelor's in political science in Afro-American and African studies from the University of Michigan, and his JD and PhD in political science from the University of Chicago. He's also worked as a law clerk to Judge Rosemary Barkett of the U.S. Court of Appeals for the 11th Circuit, and a litigation associate at Jenner & Block LLP in Washington, D.C. His articles have been published in the Penn Law Review, NYU Law Review, Vanderbilt Law Review, Stanford Law Review, and elsewhere. And he has a forthcoming contribution to the Oxford Handbook of American Election Law, and that's entitled Political Parties and Primary Elections. So we are right before the congressional elections in the US. It's a very, very timely topic. You know about the discussions probably in the US about voting rights. I'm very glad that we're able to include this in today's discussions on democracy, and very happy to welcome you, Joshua Salas.
Well, good afternoon, everyone. It's wonderful to be here. Thank you to the Carl-Schurz-Haus for this invitation. Thank you to Frederica in particular. She's the reason that I'm here. I think this morning, I forgot how she said it exactly, but we were at an event together in Berlin last month, and I think she said she cornered me or pounced or something. It was not that dramatic, but she did encourage me to come, and I'm very grateful for that invitation, and have already enjoyed many of the conversations that I've had with people last night and today, so it's a real pleasure to be here. Let me just give a little bit of background on who I am. Frederica mentioned that I studied university at the University of Michigan. It was during that time, this was in the mid-90s, late 90s, and as she said, I studied political science. There was a lot of scholarship in political science at that time examining the relationship between so-called descriptive representation and substantive representation. So this very much speaks to the comments we heard earlier from the representative. This question about whether, we care in legislative bodies, right, about diversity, and political scientists wanted to know if we have more women in legislative bodies, if we have more minorities in legislative bodies, does that translate into different substantive representation? So I got very interested in these questions through political science and quickly learned that in order to understand this universe, I needed to understand law as well. And so that sort of was the foundation of me developing an interest in going to law school. And also while I was in college, the Supreme Court decided Bush versus Gore. This is the 2000 decision that, it's common to say decided the election, but what that signified to many of us was that the Supreme Court and federal courts more broadly were going to be playing a very important role, a central role, some would say a problematic role, in regulating our politics. And so those events combined, the political science work, the Bush versus Gore decision, sort of led me on this path to being a law professor and studying election law in particular. And I had no idea at that time, because election law was sort of a subfield, that it would turn into what it has. Of course, today, election law is front-page news almost every day in New York Times, Washington Post, and there's a lot of angst and consternation in the United States about what's happening to our democracy. So I am grown accustomed to sort of apologizing at the start of my presentations because I don't want to depress people. And I learned from John earlier about how to be positive and uplifting, but I'm a bit more cynical and a bit more realist and I don't want to say sober-minded, but we have to kind of contend with the severity of the threats that we're facing. And some of those threats are long-standing and they are structural, and we heard earlier about the Electoral College and the fact that 2 of the last 5 presidents lost the popular vote, and experts anticipate that that is a trend that might continue. We might continue to see presidents being elected that lost the popular vote, often by millions of votes. That's a real threat, right, to the legitimacy of our presidential elections. And it's also the case that the Supreme Court is now firmly in the hands of a conservative majority. And we have to contend with the fact that that's likely to be true not only for the next few years, but possibly for decades to come. And even before Justices Amy Coney Barrett and Brett Kavanaugh joined the court was already somewhat hostile to political equality, I would say. Had gutted the Voting Rights Act in a notorious 2013 decision, Section 5 of the Voting Rights Act, one of the central provisions. Did the same to Section 2, another central provision in a decision last year. And just heard oral argument in another Voting Rights Act case 2 weeks ago that I fear will do further damage to the Voting Rights Act. Campaign finance jurisprudence, you heard about this earlier as well. The court has steadily allowed more and more dark money. This is money that we don't know the origin of to infect and impact our political campaigns. And in the area of partisan gerrymandering, which I'm going to have a lot to say about later, and I should say, for those who may not have background in this, partisan gerrymandering refers to the manipulation of our electoral districts such that incumbents can stay in office or one party can gain more seats than is warranted based on their vote share. So I'll sort of explain that process in greater detail later. But the Supreme Court said a couple years ago, we're no longer going to police partisan gerrymandering, right? We're getting federal courts out of the business of even hearing these kind of cases, which is yet another sort of threat to our democracy. So I could go on and on with these examples, but these are just realities we have to live with, and we're thinking about reform. I think we're unlikely to find that, certainly at the Supreme Court, and you would think that Congress, right, would step in and maybe remediate some of this, and Congress has the authority to do so, but Congress has its own deficiencies, and Congress failed to enact either of 2 big pieces of federal voting rights legislation that were under consideration in recent years. And you have senators, including one of my home state senators, Kyrsten Sinema in Arizona. The other would be Joe Manchin from West Virginia, who have a very firm commitment to preserving the filibuster. And so we are just unlikely to see any reform coming from Congress for these reasons. So the federal government is not there to save us. I guess that's the summary of what I'm trying to say. Things at the state level are a bit more complicated, but also, somewhat bleak, to be honest, in many places. In red states, we are seeing very aggressive attempts to suppress votes. Many of you may have read about the very onerous election law that the state of Georgia passed last year. It contains a number of problematic provisions, but one of the most notorious ones is a prohibition on the distribution of food and water to anyone while they're waiting in line to vote. And this, of course, raises the question of why is anyone waiting in line so long that they would want or need food and water, but that is, of course, a function of closed polling places and such. So, again, one example from Georgia. Another sort of remarkable example from the state of Michigan involves a law that the legislature passed there that prohibits hiring a private driver to take you to the polls. So when I first read about this, I had the question many of you may have, which is, what is that about, right? What is the source of that? Why would the legislature get together and pass a law prohibiting, the hiring of private drivers? And it's because black voters predominantly were the beneficiaries of groups that would help them get to the polls. They would hire vans or buses, right? And these were private, groups that would aid voters. And so the Michigan legislature thought, let's ban the use of private drivers. And both of these laws, the Georgia law and this Michigan law, were both upheld recently in various federal courts. So it's not just a matter of filing lawsuits and overturning these outlandish laws. The law, the legal doctrine, is actually fairly hostile to voting rights, I would say. I would be remiss if I didn't mention all of the so-called election deniers who are running for office this cycle. Republicans who still believe that Joe Biden is illegitimate and that President Trump is the rightful president. I think the Washington Post reported last week that 51 or 2% of all of the Republicans running for Congress or state offices next month are election deniers. I mean, that's an extraordinary number. This is not a minority of legislators. In the Arizona state legislature, I believe 81% of the Republicans in the legislature are election deniers. So this is a real, again, a severe problem that we have to be realistic about. One more depressing thing, and then I'll move on. I can't promise it'll be the last, but for now. And this speaks to actually the conversation that we started with this morning about thinking about democracy, and again, to go back to the John Dewey quote about it being a mode of associated living. We have to also contend with public opinion, right? And what large segments of the American public say that they want. And this is something that is difficult to deal with, it's difficult to conceptualize, it's difficult to come to terms with, particularly as we think about democracy as in communitarian ways, right? And thus being a civic project that we're all in together. We have survey data, we have studies that show large segments of the American public believe that it's okay to use political violence against your opponent in some circumstances. Troublingly large percentages think that we are on the verge of civil war or something like that. Troublingly large percentages think that white Christian America is under attack from immigrants, by immigrants and minorities. And so these are, again, reported findings, views that people hold. And so if we're thinking about reforming our democracy, we have to be realistic about the strength of those views as well. We can theorize, right? We can theorize and and certainly advocate for a more kind of communitarian view, but we have a long way to go, right, in thinking about ourselves as real neighbors who are in this project together. So despite all of that, and here's where I want to try to turn to be a little more positive. I've been gratified by, and here I'm really talking about scholarship, work that some of my colleagues in the election law field have done to try to unpack the implications of some of these electoral questions on racial disadvantage and racial disparities. And I say that because for so long, right, we have been sort of oblivious to a lot of these consequences. And as of late, there are people who are much more focused on trying to identify what the actual relationship is between some of these election law doctrines or electoral structures and some of the actual impact that they have on people's lived experience. So I want to give sort of an example of what I mean by that. And again, I think this is a positive development because at least now we have more accurate information about what's happening and what the relationship is. That will help us to produce remedies. And it's also true that this can help in our rhetoric in how we talk about the significance and the importance of election law. And so I want to take us to Wisconsin, not only because it's one of the epicenters of the sort of anti-democratic move, but also, of course, because, Freiburg has a sister city with Madison. And so Madison, I have nothing bad, Mary, to say about Madison. Doing a wonderful job in Madison, but the picture in Wisconsin more broadly, and certainly in Milwaukee, is a bit more problematic. So I'll use an example of partisan gerrymandering to kind of make this point, all right? So again, for those who may not have background in this, in the United States, we take a national census every 10 years, and we count all of the people in the country, and then that count is what informs how our electoral districts get divided, right? So New York has certain population, so New York gets 25 districts. If over the course of the decade, let's say, a bunch of people leave New York and move to Arizona, after the next census, maybe New York will only get 23 districts, right? So this is how the process works. And the process of drawing the lines is very contested, right? It's very politically controversial, in large part because it is the legislators, the state legislators, that in most places have the power to draw those electoral districts. So already you can see the problem here, right? This is a classic instance of, the foxes guarding the hen house. Why would any state legislator have an incentive to draw the districts in a way where they would lose, right? So that's a problem. But more broadly, parties know how to take advantage of this. If your party controls the state legislature, you can design the map in a way so that your party will get more seats than it deserves. And this is precisely what happened notoriously in Wisconsin after the 2010 census. So the Republican-controlled state legislature there created a very one-sided map. It heavily favored the Republican Party. If I remember correctly, the Republican Party lost. They got fewer than half of the votes. They got the minority of the votes, but yet they captured 66 of the 99 districts in the state. So you can see the disparity there just from this manipulation of the lines. And so there was just a rash of scholarship and commentary about how unfair this was. And, I'm interested in this, so I spent a lot of time reading it. And the sum of it focused on how the Democratic Party was hurt, right? This was disadvantageous to the Democratic Party, which of course it was, and how Democrats got a raw deal and they should have had the majority of the seats, and there were all these metrics that were created and mathematical formulas to assess partisan unfairness. And I'm not denigrating any of that. This was essential work that needed to be done, and in fact, one of those mathematical formulas was at the center of litigation about whether or not the map was fair or not. So all of that's very important. But I read all of this work, and to me, I was interested in how did this actually affect people in Wisconsin? And in particular, how did it affect minorities in Wisconsin, right? It's not just that one party got an advantage. I wanted to know how does that actually translate into racial disadvantage? And when you look at what happened in Wisconsin from 2010 to 2020, you get a much richer sense of what the costs, if you will, of partisan gerrymandering are. And so here I want to cite one think tank, which referred to Wisconsin as ranking among the worst states in the country in terms of racial equality. Black unemployment in the state exceeded that of whites by over 7 percentage points. The median white household income was twice that of black households. 3 of 10 African American families live in poverty. Black grade school students in Wisconsin were scoring at or near the bottom of national student achievement measures. And black incarceration rates were staggering. There was another report referring specifically to Milwaukee, which is a majority-minority city, that referred to poor economic, educational, and social outcomes for black children in the city. Again, large racial differences in incarceration rates. A city of what the report called concentrated poverty, cumulative disadvantages, and daunting challenges for neighborhood revitalization. Now, the governor at the time was a man named Scott Walker, who got some national attention and was thought to be a possible presidential candidate. That turned out not to be the case. Also, Republican, so he was, in line with the legislature. And rather than addressing these challenges in earnest, he decided to attack organized labor. He signed legislation drastically limiting the collective bargaining rights of unions. He cut welfare benefits markedly. And Milwaukee was targeted by the state, which tried to strip away some of its autonomy. So through, preemption, right, saying basically the state makes the decision for the city doesn't have its own authority to make its own decisions. So when you look at this collectively, you can see, right, in a very concrete way how partisan gerrymandering actually impacts people, right, and worsens these racial disparities that we see in the United States. And so what I've argued in some of my work is that, and again, this may seem paradoxical that I'm referring to this as a positive thing. It's a positive thing in that scholars are actually now devoting attention to unpacking this and to gaining clarity on the consequences and effects, right, of these electoral structures. We weren't doing that before. So we don't need any more 30,000-word articles on partisan unfairness that don't also speak to how this actually impacts people's lives over the course of, a decade. The governor also went on to reject the Affordable Care Act's provision that would have expanded Medicaid expansion in the state, and the state defunded public education, which also worsened the racial opportunity gap. And so, again, I say this as a positive because I want more clarity on these issues, but I also have to be honest and recognize that this is not what many others want, right? Many others would prefer that we talk about these things in a sort of colorblind manner or a colorblind fashion. And that is the sort of tension that I want to throw out to all of you, which is, one of these large questions. Maybe we can discuss this at the panel later this evening. But you see this tension not only in the scholarship I've referred to, but also in journalism and in policy discussions these days about what is the best and preferable and most likely to succeed strategy for reform. Should we conceptualize things in these race-specific ways and in these race-conscious ways, and should reform efforts be race-targeted, or should we take a universalist approach and one that doesn't expressly mention race? And this is one of these sort of fundamental tensions that I think the country is wrestling with. In some ways, we always have been, but it's manifesting in new ways recently. And I'm seeing more and more commentary of this sort, again, among journalists and all types of folks. And I don't have a great answer for it. It's inconceivable to me that we would do away with, for instance, the Voting Rights Act, which requires us to take race into account in some circumstances. But I also read this literature that says when you frame things in racial terms, sometimes you lose popular support. There is a cost to that. And particularly among white voters who, when they see things coded in racial ways, are put off. And so maybe there's work to be done by pursuing universalist programs. And I have ideas about universal reform. I have a lot of writing on election administration and the work that we could be doing to bolster and protect those who actually are engaged with the nuts and bolts of running our election. In general, I'd like to see much more money invested into election administration. I'd like to see much more time committed to developing professionalism and capacity among election administrators. I'd like to see more commitment to democratic structures within election administration, so opportunities for stakeholders and other community folks to give feedback about what's working, what's not working. And all of that is universalist, right? None of that has to be framed in racial terms at all. These are just, I think, good government programs that would actually have the result of improving the voting experience for a lot of people, minorities included. But wrestling with that tension, because many others would say, no, we have to frame things in expressly and explicitly racial ways. is, I think, again, one of these real fundamental challenges, and I would be interested in hearing what others think about that. I want to close just by saying, and trying to be more optimistic, I mean, I think that even in the sort of bleakness of the moment, when politics is as fraught as it is, it's good to remember that most people who are engaged with running elections are good people, are public servants, care, right, about doing the right thing and making sure that our system functions smoothly. The election administrators that I know and have worked with are open to collaboration. They are interested in scholarly projects that help us identify what's working, how they can improve, whether it's by shortening polling place wait times or expanding voting rights for the disabled. And so I think I have to remind myself of that. You know, I can read about the election deniers, and that's of great concern. But one of the benefits of our system, it's a very unique system, is its decentralization. We have close to 9,000 electoral jurisdictions in the United States, I believe. That's an enormous amount, right? They each have their own things that work. What works in one place may not be appropriate for another place. So this is one of the great strengths of our system. But that also means there's a lot of opportunities for, you know, mischief and abuse. But on balance, I think that decentralization is a good thing because it prevents an infection of one part of the system from overtaking the system as a whole. And we certainly saw that in the wake of the last presidential election, where the decentralization was shown to be an advantage. And so I don't want to lose hope about reform efforts. I think that, again, there's plenty of space for us to do positive things. But I do that, again, very cognizant of the sort of trend towards anti-democracy that we're seeing in many, many places, and that I think, as I've learned in just a couple of months that I've been in Germany, is great concern not only to those of us right in the U.S., but certainly people in Germany and in Europe more broadly. And so I'm happy to talk about anything election law related or answer any questions you might have, either about the racial equity stuff or Supreme Court or the midterm elections. But I want to reiterate, I am also interested in general thoughts others might have on this fundamental tension between race-focused remedies and strategies versus the universalist approach. Again, maybe this is more appropriate for the panel, but I'll put that out there.
A question and a comment. The comment first, I wanted to let you know that we do a racial analysis of our elections, an equity analysis of our elections with community groups after the election in Madison. So I think that's helpful. But I'm curious, I know some idealistic people in my family, in my community, who think that a constitutional amendment on the right to vote sort of solves all these problems. And I've always been sort of scratching my head, wondering if that would really, solve the gerrymandering problem, for instance. And I was just curious if you had any thoughts on that.
Yeah, I have many thoughts, unsurprisingly. Let me make a conceptual point about the right to vote, which often gets overlooked. Okay, the right to vote is not like other rights. We have what are known as negative rights or negative liberties, for the most part, right? If I want to exercise my free speech rights, all I want, in essence, is access to the soapbox or access to the park. I want the government to just leave me alone. You can't regulate my speech through prior restraint or punish me after, just leave me alone. That's true for almost all of our rights, right? Even the Second Amendment rights. This is the United States' most controversial right, I think, the right to bear arms and carry guns around. I don't support that right. I don't agree with the Supreme Court that it's found in the Constitution, but what do those folks want? They just want to be left alone, right? Free to carry their weapon around town. The right to vote is conceptually different because I can't exercise my right to vote unless the government provides me with the apparatus and the infrastructure to allow me to effectuate that right. It's fundamentally different in that way. So the government has, in my view, an affirmative obligation in this context to create that infrastructure in a way that works for the citizenry. So that already is different. And I think a constitutional amendment affirming that right to vote would be a positive thing in that regard, right? It would remind people that this isn't like the other negative rights or negative liberties that we have. Now, would it be a panacea? Absolutely not. And I don't know how I would draft the language such that it would cover every imaginable circumstance, right? We have nothing inherently, there's no content that is at the essence of the right to vote. We have to sort of imbue the idea of the right to vote with content. That's why we have endless litigation about it. We say we have the right to vote, fine. Does that mean that you should not have to show an ID? Does that mean you should have 2 weeks of early voting? Does that mean you should be able to register on the same day you want to vote? What does that mean in practice? We have no collective agreement on that, so we have endless fights and litigation about that. So let's shore up the foundation of the right to vote in some meaningful way and give it content that we can all agree at a minimum. At a minimum, this is what should be provided, regardless of where you are. No one should have to surmount certain obstacles beyond a point. And no one should be certainly intentionally targeted for exclusion, which is all too common in the U.S. right now. We'll get up here. It'll work its way up. Yeah.
First, let me thank you so much for sharing your insights today. You've spoken at length about the importance of state legislators in addressing, voter inequality, or even at their worst, creating them. I think one of the reactions to that we've seen is a more focused approach to, grassroots movements in addressing more equality, both social and racial. So I guess my question is, how do you view the chances of those grassroots movements in creating more equality?
I think they're essential, and I think the history of the country shows that and proves that. We have not seen anything close to comprehensive reform in this country without fights and mobilization. And so, in my mind, that has to be an essential part. Now, what form that mobilization takes, right? We can have conversations about that. But I think that in the face of the hostile state legislatures that you point out, mobilization and activation of the electorate is essential, because this is the ultimate check, right? This is to go back to why I am constantly wrestling with the survey views that I mentioned about people's belief systems, and why I lose sleep over that, because I was always taught, and it's firmly my view, that we, the people, are the check, right? On a rogue legislature or a rogue president, we can vote the bums out of office, right? That's what the system was designed. But half the people, they don't want to vote the bum out. They love what the bum is doing. So at any rate, I think there is promise in mobilization, but we have to sort of also be aware that mobilization can take forms that we might not agree with, right? And we have learned that, and we've learned that very clearly in recent years back home. Right here.
Yeah, thank you so much. I would like to ask a question. Sorry if it's too provocative, but would you say that America, the US, is a democracy with two parties and so many people not being able to vote? I mean, I think the prison population isn't allowed to vote. You need to register to vote. Yeah. That's just so much. So at the end, there's a very, the minorities is the one at the voting booth at the end. And can we then still call that democracy, especially when you have things like 70% of all Americans agree on sensible gun control laws, but still a very small minority, and the NRA pushes the representatives to make this really bad laws?
Yeah, I mean, it's a profound question. It's a hard one to answer because we have no agreed upon definition of democracy. You know, what makes a democracy? In some ways, I think we are undoubtedly a democracy, but I think we are a flawed democracy, and I think we have always been a flawed democracy for some of the structural reasons that we heard about earlier from John. We have systems in place which permit a minority to take control, and for various historical reasons, with a couple of exceptions, that has generally not been the case. It is undoubtedly the case now. Now, does that make us a non-democracy? I don't know, but it certainly makes us a hobbled one. And whether it's because of the Supreme Court, whether it's because of the fact that each state gets 2 senators, whether it's because of the Electoral College, whether it's because of sorting of people and where they live, whether it's because of partisan gerrymandering, as a result of all of this in combination, you're right. The Republican Party now feels it does not even have to follow public opinion. And the Supreme Court, you know, which is institutionally free from having to do so, feels freer than ever, right, to enact a sort of conservative activist agenda that doesn't follow public opinion. So I think we are, again, a democracy that is struggling. I think there are some, I don't know if I would say existential questions that are facing. I'm not of the view that the democracy is going to collapse, but I am of the view that we are going to see more and more sort of very specific types of tensions manifest. And there may be, I've been mentioning Jamel Bouie a lot lately because I think he's been very clear-sighted about this. He's a New York Times op-ed writer. I think there will be a sort of horizontal splitting or sorting in some ways of the states. We're already seeing this, as you know, in the realm of abortion rights. So rights will expand in some states and they will contract in others. And the question is, how will citizens and companies and other entities, for that matter, negotiate that split? So as an example, you know, California enacts laws that say to companies, if you want to do business in the state of California, this enormous market, here are some environmental regulations that you have to comply with. And then Texas immediately says, if you comply with those regulations, you can't do business in Texas, right? Another enormous market. So I think we're likely to see more and more tensions like that. But I don't think we're going to see the complete collapse of the system, even though its legitimacy is in question and many, many people are doubting, you know, its function. But one of the positive, I often say this, I was gratified by the turnout in the past election. It was abnormal for us. Of course, I vehemently disagree with those who felt we needed another Trump, presidency. But the turnout was gratifying because the turnout at least signifies people's commitment to the process, which is better than the alternative of chaos and violence and disorder and nihilism. So I take some solace in the fact that people are at least participating. That doesn't excuse or absolve at all the legislators and other officials who are exploiting the process and the weakness of the process to instantiate minority rule.
I agree with almost everything you've said, although I'm struck by your enthusiasm for the diversity of our electoral processes, right? The different districts, 9,000 as you say, and every state in the United States having a different set of election rules.
Yeah.
And it strikes me that when I covered, as example, the transition from apartheid to democracy in South Africa, they set up an election, the central election board, a central set of rules, and maybe some places could do a better job, but nobody could fall below a basic line. And it strikes me that in the United States, we now have a situation where if you live in certain states, your votes, your ability to vote is easier, your certainty to have that vote counted is easier. If it's a close election, you will have a clearer recount process, et cetera, et cetera, et cetera, down the line. And doesn't that create a massive inequality? That if I live in a state that makes it very easy to vote, like Minnesota, I have more democracy than somebody that lives in a state that makes it very hard to vote, say like Georgia.
Undoubtedly unequal and arguably very unfair. As a constitutional law professor, of course, my mind thinks, well, this is baked in, right? It's baked into the founders' design. They've empowered states, as you know, right, from the first moment to say, states are the ones that define voter qualifications. And your ability to vote in the state is tethered to your ability to vote in federal elections. That's the system that they established. So an alternative would require a constitutional amendment, which politically is a non-starter. So I entirely agree with your diagnosis, but I don't know how we could remedy that in any practical way. And you pointed out earlier, right, you compared Wyoming and California. There's inequality there as well, right, just by virtue of the fact that, one representative can be elected by 100,000 people, another takes, 1 million, depending on what state you're in. And so unless we're going to do away with state sovereignty, which is not going to happen, I think this is the system we're stuck with. But I think maybe at the heart of your question is this question about national standards. And I was in favor of both pieces of federal voting rights legislation, but I did agree with some of the critics who pointed out that a one-size-fits-all approach actually presents problems for a lot of jurisdictions. And this goes back to my interest in election administration. This was a proposed federal law that would have required 2 weeks of early voting for every jurisdiction in the country. And intuitively, you think that makes good sense. Except you have to take into account that it costs money, right, to keep polling places open for 2 weeks, or to have machines available for 2 weeks, or to hire poll workers. And some jurisdictions are very small, and they don't have many people in them, and they don't necessarily need 2 weeks. And so unless we're going to give them the resources to keep the polling place open, it's not a good investment. Now, that doesn't mean the federal law shouldn't have gone forward, but it means we should refine the law or the language such that there are carve-outs or exceptions available. And this is one of the, because we have such a highly decentralized system, we have to contend with these differences across jurisdictions. So I would just keep that in mind as well.
We have one more question for you.
Yeah, I wonder if you could comment a bit more on the anti-democratic tension as concerns the Supreme Court today, in light of how in earlier moments the court has also expressed an anti-democratic tendency, but one that bended toward, I think, what we would all call progress. Brown versus Board of Education, the later decision about gay marriage, those are decisions that, if put to a vote at those given times in America, at least if we did it state by state, there would certainly be states that would, the majority would be opposed to the decisions that the court made the law of the land. In a way that I think we would all agree served the interests of the democratic project, but that's of course in the eye of the beholder. And so how do you see then this tension having both a kind of working for the force of good and forces of progress and anti-progress, and can there actually be a unifying idea or concept or goal that we should strive toward when we think about the court reflecting the will of the people, thus making it democratic? Is that something we actually want to strive for? Is there another goal that we should be articulating?
I think there is another goal. So again, another profound question, one that a lot of people wrestle with, constitutional law scholars wrestle with often, which is, we romanticize the Warren Court, right, which issued all these progressive decisions, Brown versus Board of Education and Miranda versus Arizona, and create all these criminal procedure rights. Baker versus Carr, which is the case that established the principle of one person, one vote, so the electoral districts have to contain the same number of people. These are Warren Court highlights, and we say, look how good that court was, right? Look how progressive that court was. But many of those decisions at that time broke precedent, broke new ground, right? Did the same things that we criticize the Roberts Court of doing today. And so I think that the court is always operating as in sort of a second order fashion. And so to your question, we have to engage with first principles and I think articulate our theories of justice and fairness and morality. And that's going to differ from person to person, but there's no way that that can't be the metric for judging what we think the court is up to. Now, I say that with one caveat, and maybe this is revealing my political views here, but the recent decisions are poorly reasoned on their own terms. They're so badly reasoned by conventional legal understandings of legal interpretation and how to do constitutional law that they seem not all, but many seem qualitatively different even from those Warren Court decisions. But that's my, that reflects my sort of approach to interpreting the Constitution, how I read provisions against one another, what I think the court's role in society is. So it's a complex interbranch dialogue that's happening in conjunction with public opinion. I think you can justify cases like Brown on many grounds that you couldn't necessarily Dobbs, for instance. But I think the first, the point about first order principles aren't having to necessarily be part of the analysis is an important one, and one that frankly a lot of legal scholars, often sort of elide, right? Because then you're in the realm of philosophy, and then you're in the realm of morality, and that's for most of us not our training, so we get uncomfortable, and you throw out, John Rawls or something, but we need to spend more time, I think, thinking about how we can, defend the difference that you identify. Thank you.